Good morning, this is John Lynch for our usual COVID-19 talk. Today I'd like to talk about grants of probate or letters of representation. Effectively what we're talking about here this morning is if you die in the morning, what kind of legal mechanism comes into play in the context of ensuring that your will or the wishes under your will are implemented. Now, we previously in other talks talked about executors, who are the people who are given the job of looking after your affairs after you have passed away. A grant of probate is the legal document that's required to ensure or to empower a named individual to actually carry out your instructions. The carrying out of your instructions, i.e. taking out a grant of probate or letters of administration, involves the process of gathering in all of the assets as a step one or as a first stage, protecting the assets as part of that particular stage, and then the intervening period is collating all of the information, lodging the paperwork with what is an office called the probate office, and the probate office will vet everything, ensure that everything is a-okay from a paperwork point of view, and will then issue a letter of authorization, which is called a grant of probate or letters of administration. I think it's probably important at this point to point out that the probate office, like the property registration authority or the land registry, is there simply as an office of record. It's there to record the transaction involved. In the case of the property registration authority, you're talking about land transactions. In the case of the probate office, you're talking about will transactions or transactions involving administering somebody's estate after they've passed away. And the main reason that I would point that out to you is that their job is simply to ensure that the paperwork is correct. They are not going to make any adjudication on issues around the will, whether the will was properly made, whether the paperwork can be altered in any way, or whether there's a dispute on whether the person was able to, had the competence to, or was being influenced in making the will. Things like that are entirely a matter for the court and not for the probate office. If we just move on in terms of the kind of methodology that's involved in this, once you gather in the assets, and as I said, we previously talked about who it is that has this job, they're called personal representatives, and they will be, under the will, they'll be named individuals called executors. If there isn't a will, or if the will doesn't deal properly with executors, then you have what you call administrators. A similar type of a role, just a different name. And these administrators and or executors, who are called personal representatives, their function and duty is to carry out the various stages of the transaction. The first stage being, as I say, dealing with the paperwork and also dealing with the assets and liabilities, trying to establish what they are. Once they get the document, which is the grant of probate or letters of administration, this is an authorization that effectively means that they can now carry out the instructions of the deceased and or apply general rules of law where, for example, there isn't a will. Just to clarify on that, you have the term testacy and intestacy. They're the two terms that are commonly used by professionals. Testacy is where there is a will and therefore a written instruction on what to do and how to, and who should benefit and what kind of assets are involved in the estate. The other one is where there isn't a will, and then you literally have kind of default rules that come into play under the Succession Act of 1965, and they just literally set out who gets what and how they're distributed. So if you don't make a will, the law will kick in and apply those rules. So in terms of the second stage, once you've got the authorization, it's kind of a linked scenario. you get and gather in all the assets, make your application. Once you get the application through and you've got your document that authorises you to carry out the functions as the personal representative, then under those circumstances, then you're into phase 2. Phase 2 is implementing the wishes under the will or applying the rules under the Succession Act, and that is distributing the estate. By the way, I'm working on the assumption that there is an estate to distribute, and i.e. that the estate is not an insolvent estate, because if it's an insolvent estate, that's a different kettle of fish and different rules apply. In the case of a solvent estate, there are preset rules as to how you do it if there isn't a will, and if there is a will, then you are dealing with a situation that you carry out the instructions under the will. Just one little final add-on to this is that, generally speaking, when you make a will, if you don't make a will, there are rules that apply. If you make a will, the rules that apply are generally those set out in the will. In other words, if you make a will, you can do whatever you like effectively under the will in general terms. But there are a couple of notable, when I say a couple, two that come to mind, notable exceptions to that, and that is the position of a spouse or partner in those circumstances where you've got a spouse scenario. You have what they call the legal right share. Now, this is obviously something that we can discuss in more detail in subsequent talks, but as a general rule, the legal right share gives the spouse or civil partner the option, and the important thing here is it gives them the option to override the will if the will doesn't properly provide for them under a kind of a default provision. Now, again, just to clarify that, so if you're looking at a situation that there are children, you are entitled to a third as a kind of a yardstick. That's the benchmark. You're entitled to a third of the estate. So if you have a will where there is not a bequest in there or something in there that gives you, if there's something in there that gives you less than the 1/3, then you're obviously entitled to contest it insofar as you can exercise your legal right share, which will override the provisions of the will. So that's one situation where you can't necessarily do what you like. The other one is, it's more to do with an entitlement, and that is what we call a Section 117. Again, something for another talk. A Section 117 is effectively where you make a claim as a child, and your claim is literally based on the fact that you have not been properly provided for under the will. Now, there are very particular and specific guidelines issued by the courts as to how and when the courts will intervene and override the wishes of the person who has made the will. So again, that's just to wrap up. The mechanism that we're talking about is letters of administration, which can be called grant of probate or letters of administration. They're the two kind of mechanisms to give you the legal authority to literally deal with somebody's estate. This is John Lynch from Lynch Solicitors in Clonmel. Again, thank you for listening to me. We're going to upload all our videos onto our YouTube channel. So if you'd like to Google us, Lynch Solicitors, and our YouTube channel, you can select and subscribe to the channel, and you'll get up-to-date notifications every time we issue one of our little talks. Thank you again for listening to it.